Standing behind me is the Canadian Museum for Human Rights, a national monument to the necessity for protecting human rights. While this building tells the world who Canada claims they are, the reality for Indigenous peoples tells a very different story. Canada sees itself as a global human rights leader, a country of peace-building, reconciliation, and international law. But what if beneath this image, it is failing one of its most fundamental legal obligations, the duty to prevent genocide? Although no legal case has been tried, the federal government of Canada has faced its fair share of allegations of genocide against the Indigenous population. In 2015, the final report of the Truth and Reconciliation Commission concluded that Canada's residential school system amounted to cultural genocide. And in 2022, the House of Commons passed a unanimous motion calling on the federal government to recognize the residential school system as genocide. That call has remained unanswered. This video does not argue that genocide is currently occurring. Rather, it addresses whether or not Canada is at risk of violating their obligation to prevent genocide against the Indigenous population in the country. To answer this question, I first analyzed the legal understanding of genocide and what Canada's obligations are to prevent it. In doing so, I also examined Canada's role in drafting the United Nations Convention on the Prevention and Punishment of the Crime of Genocide, and how its participation in shaping this convention absolved it of legal claims of genocide made against them. After those facts have been established, I will then discuss how Canada may be at risk of violating their obligations in regards to three issues experienced by Indigenous peoples nationally. The first is the crisis of missing and murdered Indigenous women, girls, and Two-Spirited people, as they are disproportionately targeted by violence, where systemic failures of policing and justice continue to leave families without answers or accountability. The second is the child welfare system in Canada, where Indigenous children are vastly overrepresented in care, a continuation of colonial policies that remove children from their communities and sever their connections to their Indigenous culture, identity, and families. And third is access to basic necessities of life, as many Indigenous communities still lack access to reliable drinking water, adequate housing conditions, access to equitable health care, food, and community services, conditions that directly impact survival and well-being. Before we dive into my analysis, I would like to acknowledge that I am on Treaty 1 territory, the first of the 11 numbered treaties that Indigenous peoples were forced into agreement with the Government of Canada in 1871. Since its signing, the Indigenous peoples of Treaty 1 have continued to suffer, experiencing discrimination in private and public sectors, violence, and racism, while the settler community continues to reap the benefits of this agreement. These lands that settlers occupy in Winnipeg are the traditional territories of the Anishinaabe, Aninawak, Assinininawuk, Dakota Oyate, and Dene. As settlers, it is our responsibility to collaborate with and be guided by the knowledge that the Indigenous peoples of this land harbor, so we can live together with equal and equitable resources to participation. Genocide is either classified through a colloquial or a legal definition. It is commonly understood as mass killings. We recognize the Holocaust as genocide because of the targeted killings of the European Jewish population and other minorities through Nazi concentration camps, where millions were killed because of their identities, or the Rwandan genocide because of the estimated 800,000 Tutsi killed in a matter of months. Raphael Lemkin, the scholar who coined the term genocide, distinguished between physical, biological, and cultural genocide. He defined physical genocide as the physical destruction of a group, biological genocide as acts intended to reduce the birth rate of a group, and cultural genocide as the destruction of the specific traits of a group. The legal concept of genocide, however, refers to specific atrocities that are intended to bring about the elimination or destruction of a group in whole or in part. These acts have been defined in the United Nations Convention on the Prevention and Punishment of the Crime of Genocide, which, throughout the remainder of this video, I will refer to as the Genocide Convention. What distinguishes genocide from all other crimes is the special intent that is required. This special intent is called the dolus specialis, and it is the specific intent of the perpetrator to bring out the destruction of a group in whole or in part. The Genocide Convention was developed from 1946 to 1948 in response to the atrocities of the Second World War. Representatives from dozens of countries came together to create the articles of the Genocide Convention that define genocide, the obligation to prevent it, and the obligation to punish it. The evidence of their negotiations has been compiled into what is called the Travaux Préparatoires, which is the name given for the official record of negotiations and early drafts of the final form of this convention. When cases of genocide are brought to the international courts, the judges will refer to the travaux préparatoires to aid their interpretation of the law in light of the relevant facts of the case. Canada had several representatives at meetings regarding the drafting of the Genocide Convention. It was a big supporter of a convention on genocide, but with one condition: that cultural genocide be excluded. Having read through the travaux myself, Canada's representatives were most active in sharing the federal government's opinions when cultural genocide was discussed. For the remainder of the drafting process, they took a backseat. The draft of the Genocide Convention, written by the United Nations Secretary General, proposed that cultural genocide could be defined as acts carried out with the intent to destroy the culture, language, or religion of a group, including the forced transfer of children from one group to another, the prohibition of speaking native languages, even in private spaces, the systematic destruction of books in native languages or prevention of new publications, and the destruction of cultural and religious monuments. Canada's representatives asserted that Canada was a country of two cultures, Anglo-Saxon and French, with a great number of minority groups, seemingly categorizing Indigenous peoples as only a minority group, while continuing on to share that no other country was more concerned with the preservation of cultures than Canada. They stated that the Canadian government and population would be appalled at the idea of cultural genocide, but they opposed its inclusion in the Genocide Convention, preferring a more limited definition of genocide: the destruction of human groups. Several justifications were presented for this objection. They argued that the physical destruction of a group was more significant than the destruction of a culture. They felt that the concept of cultural genocide was a human rights and minority rights issue and could potentially lead to confusion and become a deterrent for states to sign and ratify the Genocide Convention. This objection to the inclusion of cultural genocide in the Genocide Convention ended up being Canada's only major contribution to the final form. As a result of a vote amongst the committee decided that provisions relating to cultural genocide would be excluded. This work absolved Canada of claims of cultural genocide made against them in regard to the residential school system, of which the purpose was to assimilate Indigenous children into settler culture, effectively cultural genocide. Now, if legal claims of genocide are to be made against Canada, they would have to satisfy the physical or biological destruction. As a compromise to the exclusion of cultural genocide, a provision relating to the forceful transfer of children from one group to another would be included in the convention. Attempts to revive the notion of cultural genocide have been made, however, have not been successful. This takes us now to Article 2 of the Genocide Convention, which lists the acts when committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such, constitute genocide. Because international cases regarding genocide can be brought to the International Court of Justice, which settles disputes between states, and the International Criminal Court, which prosecutes individuals for international crimes, interpretations from both courts will be used in this analysis. The first provision under Article 2, the killing of members of a group, covers the act of killing that amounts to genocide. The trial judgment from Prosecutor V. Akiyisu of the International Criminal Tribunal for Rwanda interpreted that killing is done with the intent to cause death and assumes these acts are premeditated. In the case between Croatia and Serbia at the International Court of Justice, the court decided Serbia violated this provision based on the number of killings of those belonging to the protected group, the Croats. So, premeditated intent to kill and large numbers of deaths are indicators of violations of this provision. The second provision criminalizes causing serious bodily or mental harm to members of a group. The International Criminal Tribunal for the former Yugoslavia, in the Krstic case, determined that harm done must constitute, quote, a grave and long-term disadvantage to a person's ability to lead a normal and constructive life, end quote. The International Criminal Tribunal for Rwanda decided that rape and other sexually violent acts can constitute genocide in the Akiyisu judgment. The International Criminal Court's Elements of Crimes, which defines the elements of each provision of Article 2 of the Genocide Convention, concurs with the decision from the Akiyisu judgment, but further clarified that acts are not restricted to torture, rape, sexual violence, or degrading treatment. From Croatia v. Serbia at the International Court of Justice, it was determined that Serbia violated this provision through the acts of torture, sexual violence, and rape that caused such amounts of physical and mental harm that it could be seen to contribute to the physical or biological destruction of the Croats. So, rape and sexual violence committed with the intent to destroy a group are violations of this provision. The third provision prohibits acts that deliberately inflict conditions of life on a group that are calculated to bring about its destruction in whole or in part. Again, from the Akiyisu case, the tribunal described these acts as those that do not necessarily cause the immediate death of members of a group, but do aim to bring about the physical destruction of a group. The Elements of Crimes from the International Criminal Court interprets this provision to include the deprivation of food, medical devices, or systematic expulsion from homes. From the Bosnia and Herzegovina v. Serbia and Montenegro case at the International Court of Justice, even though the court did find that Serb forces were deliberately targeting civilians, it was not done so with the specific intent to destroy the group. The fourth provision prevents the imposition of measures that are intended to prevent births within the group. In the Akiyisu judgment, the tribunal determined rape can be a measure that prevents births within the group when the person refuses to procreate or when the women are raped with the purpose of having that child not belong to the same group as the mother. The fifth and final provision of Article 2 of the Genocide Convention criminalizes the forcible transfer of children from a protected group to another group. Though this provision has seen little judicial consideration, it was considered in the International Court of Justice's case between Bosnia and Herzegovina and Serbia and Montenegro in regard to forced pregnancies as a result of rape by Serbian men with the intention of transferring the unborn children to the Bosnian Serb group. The court, however, did not find that pregnancies resulting from rape were intended so that the children could be moved to the Bosnian Serb group, and therefore did not amount to genocide. Though Canada did ratify the Genocide Convention in 1952, 4 years after it had been adopted by the United Nations, it held limited weight in domestic law, as it was initially argued that existing provisions in the criminal code were sufficient to address genocide. It was not until 1985 when genocide was added to the criminal code, and the year 2000 when it was defined in the Crimes Against Humanities and War Crimes Act that genocide was incorporated into national law. In the criminal code, the definition of genocide has been narrowed to only include 2 provisions from the Genocide Convention: the killing of members of a group, the deliberate infliction of conditions of life on a group that are calculated to bring about its physical destruction, reinforcing Canada's position on a limited scope to the definition of genocide during the drafting of the convention, further distancing themselves from claims of cultural genocide. The Crimes Against Humanities and War Crimes Act defines genocide as acts or omissions that are committed with the specific intent to destroy a group as established under international law. Now that the legal understanding of genocide has been established, we can now define Canada's obligations to prevent it. Article 1 of the Genocide Convention is the provision that puts a duty on states to prevent genocide. Interestingly, even though the prevention of genocide was one of the main motivators for the creation of a convention on genocide, there are no provisions in the convention that define how states are to do so. So, to determine Canada's obligations to prevent genocide, we turn to judicial decisions and preliminary measures of the International Court of Justice, national legislation, and international political commitments. First, looking at the decision of the International Court of Justice in the 2007 application of the Genocide Convention brought by Bosnia and Herzegovina against Serbia and Montenegro, the court provided an explanation on the scope of prevention. The court specified that the obligation to prevent genocide does not mean that states must be successful in their prevention, but they must, quote, employ all means reasonably available to them, so as to prevent genocide so far as possible." End quote. As soon as states become aware of the risk of genocide, they are responsible for its prevention, as long as they have the, quote, "capacity to influence," end quote, and the, quote, "power to contribute to restraining in any degree the commission of genocide," end quote. States must therefore practice due diligence to identify how they can prevent the commission of genocide. The means of doing so, however, must align with international law. Although providing some clarity, the wording of the court's interpretation seems to imply that the ability of states to influence preventing genocide can be construed broadly, opening states to the expanded legal responsibility for omissions in situations where they have the capability to act. Staying at the international level, Canada was instrumental in the development and adoption of the responsibility to protect principle, which was adopted by member states of the United Nations in 2007. This principle commits states to protecting its population from genocide, war crimes, ethnic cleansing, and crimes against humanity. Additionally, it commits states to use the resources of the United Nations to take suitable non-violent action to aid in the protection of a population against genocide. Although it is a non-binding political agreement, the responsibility to protect reinforces and aids the clarification of the scope of states' duties to prevent genocide by emphasizing their responsibility to take timely action, individually and collectively, and through the United Nations, when there is a serious risk of genocide occurring. In regard to Canadian legislation, the obligation to prevent genocide can be found indirectly in the Criminal Code, again, with no provisions that explicitly detail how states are to prevent genocide. The Criminal Code does criminalize the incitement of genocide. From this provision, the obligation to prevent genocide can be interpreted as acting at an early anticipatory stage, requiring states to intervene where there is a risk that harmful speech or actions may escalate into genocide. In practice, this could mean that Canada should be expected to monitor threats, limit incitement, and implement proactive measures to safeguard at-risk groups. The most recent thresholds for genocide prevention have come in the form of provisional measures from the International Court of Justice in the application of the Genocide Convention brought by South Africa against Israel. In the context of genocide, provisional measures are made by the court when it considers that action must be taken in the time before the court is able to render their final judgment of the case, to mitigate the harm being done. The court has stressed the lack of access Palestinians in Gaza have to food, clean drinking water, electricity, essential medicines, and heating. In their fourth provisional measure from January 2024, the court stated that, quote, "The State of Israel shall take immediate and effective measure to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip," end quote. Thereby reinforcing the obligation to prevent genocide is not just reactive, but requires states to take immediate steps to prevent when there is a serious risk of genocide. This provisional measure has signaled a lowering of the threshold for triggering states' duty to prevent genocide, emphasizing that the existence of adverse conditions of life caused by the perpetrator may be sufficient to trigger a state's obligation to take preventative measures. In sum, to fulfill their obligation to prevent genocide, Canada's duties are to prevent genocide using all measures it reasonably has the capacity and capability to punish the advocacy or promotion of genocide, to provide basic services to groups experiencing adverse conditions of life, to use the resources of the United Nations to protect populations from genocide, and to act promptly where there is a risk of genocide. At the same time, however, Canada can only be found to be violating their obligation to prevent genocide if genocide is found to have actually occurred. I now begin my analysis of whether Canada is at risk of violating their obligation to prevent genocide of the Indigenous population. I focus on Canada's duty to act where there is a serious risk and its failures to take all reasonable measures within its power to prevent genocide in regards to the rights of Indigenous people. This approach is taken because Indigenous peoples continue to experience systemic marginalization, discrimination, cultural erasure, and disproportionate levels of violence, which violate their unique rights as Indigenous peoples. Even if Canada is not found to be at risk of violating their obligation to prevent genocide, there are still serious concerns regarding Indigenous rights abuses. Collective and individual Indigenous rights have been affirmed in the United Nations Declaration on the Rights of Indigenous Peoples, also known as UNDRIP. UNDRIP was adopted by the United Nations General Assembly in September 2007. However, the Canadian government remained opposed to its adoption and implementation until 2016, and it was not until 2021 that UNDRIP was finally integrated into Canada's legislation through the UNDRIP Act. Indigenous women, girls, and two-spirited peoples have vanished from their communities, later to be found deceased or never found at all. Many of these women experience sexual violence and rape before they are killed, and many of these perpetrators have been Royal Canadian Mounted Police, amongst other civilians. In 2024, Indigenous women and girls represented 30% of homicides against women in Canada, despite making up only approximately 5% of the population in Canada. The National Inquiry into Missing and Murdered Indigenous Women and Girls reported that Indigenous women and girls are 12 times more likely to go missing and be murdered than any other women in Canada, and 16 times more likely than Caucasian women specifically. Additionally, the Canadian Femicide Observatory for Justice and Accountability reported in 2020 that 1 in 5 women killed by a male accused was an Indigenous woman or girl. From all of this data, there is a clear indication of inequality and patterned violence directed towards Indigenous women and girls. Data specific to two-spirited peoples, however, remains limited. It was concluded by the National Inquiry that the systemic causes of violence against Indigenous women, girls, and two-spirited peoples stem from colonial legacies of racism, sexism, misogyny, homophobia, and other forms of discrimination. In this context, these root causes should be understood as failures by Canada to uphold its obligation to advancing the rights of Indigenous peoples. The 2 articles from UNDRIP that make specific reference to Indigenous women and girls include Articles 21 and Article 22. Article 21 establishes the right of Indigenous people to improve their economic and social conditions without discrimination, and highlights the specific requirement to consider the needs of Indigenous women. Article 22 puts a duty on states to ensure that Indigenous women are protected from violence. Therefore, the disproportionately high levels of violence that Indigenous women, girls, and two-spirited peoples face puts Canada in breach of its obligations under UNDRIP by failing to take effective measures to protect Indigenous women and girls from violence and discrimination. Recalling what was discussed earlier in regards to the interpretations of the provisions of Article 2 of the Genocide Convention, in the specific context of missing and murdered Indigenous women, girls, and two-spirited peoples, the acts of genocide that could be violated include the killing of members of a group, causing serious bodily or mental harm, and the imposition of measures intended to prevent births. So, what has Canada done to prevent this? Canada's actions have been focused on policy. In 2021, the federal government launched the National Action Plan, which is intended to coordinate efforts to address this crisis across provincial, territorial, and federal jurisdictions, and with Indigenous organizations. In the same year, they launched their federal pathway, aimed at ending systemic violence against Indigenous women, girls, and two-spirited peoples. As a component to the National Action Plan, the federal pathway focuses on 4 themes: culture, health and wellness, safety and human security, and justice. And it emphasizes partnership between the federal government and Indigenous peoples. These mitigation and prevention measures have, however, not been overly effective and have been criticized by Indigenous leaders, human rights advocates, and scholars. They have argued that the National Action Plan and the Federal Pathways frameworks lack clear responsibilities for governments and accountability measures, timelines for implementation, funding, and resource allocation. It should also be noted that the federal government was supposed to have a national action plan ready for 2020, but failed to prioritize it, which pushed its release back one full year. The findings of the Truth and Reconciliation Commission in 2015 and the National Inquiry into Missing and Murdered Indigenous Women and Girls in 2019 were the warnings to the Canadian government that there was a risk of genocide against Indigenous women, girls, and Two-Spirited peoples. Between 2020 and 2024, the number of Indigenous women who were victims of homicide per year rose from 44 to 71. And the percentage of Indigenous women as homicide victims increased by more than 5%. Clearly, the crisis isn't being effectively addressed by policy from the federal government. So, in sum, the federal government is taking some measures to prevent genocide in regards to missing and murdered Indigenous women, girls, and Two-Spirited peoples in the form of policy. However, this avenue is not effective enough to eliminate this crisis, leaving Canada at risk of violating their obligation to prevent genocide. Now we move to the child welfare system. When Indigenous children are removed from their homes, their connections to their cultures are severed. They grow up without learning their traditional languages, values, religions, and spiritual guidances, amongst other things. In a 2019 report led by the Assembly of First Nations, it was revealed that Indigenous children are 3.6 times more likely to be investigated by child welfare services than non-Indigenous children. And according to census data from 2021, although Indigenous children represent less than 8% of children under the age of 15 in Canada, 54% of children in foster care in this age category are Indigenous children. A decision made by the Canadian Human Rights Tribunal in 2016 found that the federal government was guilty of discrimination against Indigenous children based on their race, interfering with Indigenous children's access to the same public services that non-Indigenous children have. The tribunal argued that Aboriginal Affairs and Northern Development Canada's insufficient fixed funding for the First Nations Child and Family Services Program impacted the ability of their agencies to provide culturally sensitive child welfare services to Indigenous communities. This chronic lack of funding created an incentive for agencies to remove Indigenous children from their communities and place them into care because the financial costs of doing so were reimbursed to the agency. This led to more children being removed from their communities as resources were too constrained for the agencies to provide services that would enable Indigenous children to stay with their families in community. Under UNDRIP, it is a violation of Article 7 to forcibly remove Indigenous children from their communities to another group. And just like for Indigenous women, Article 22 puts a duty on states to ensure the protection of Indigenous children from violence and discrimination. And Article 24 establishes the right to all social services, which would include child welfare. Distinct from their Indigenous rights under UNDRIP, Indigenous children are recognized by the United Nations Convention on the Rights of the Child, which Canada ratified in 1991. Article 9 of this convention puts a duty on states to abstain from forceful removal of children from their parents, except for circumstances where it is in the best interest of the child to do so. Article 30 asserts that, as a minority group, Indigenous children have the right to enjoy their unique cultures, languages, and religions. Considering the overrepresentation of Indigenous children in the child welfare system, despite making up less than 8% of Canada's population under age 15, their disproportionate removal from their families on the basis of the best interests of the child highlights a profound inconsistency with Canada's obligations under international human rights law and Indigenous rights. As introduced earlier, the act of forcibly transporting children from a protected group to another group is a violation of Article 2 of the Genocide Convention. Indigenous leaders and advocates have classified Canada's welfare system as children are removed from their homes and placed into government institutions or settler foster care homes, depriving them of their connection to their Indigenous culture, similar to the practices of the residential school system. Canada cannot claim that they were not aware of this crisis. Concern over the continued removal of Indigenous children from their families was issued by the United Nations Committee on the Rights of the Child in 2012. In the same year, Indigenous advocates estimated that there were 3 times as many children in the child welfare program than there were during the peak of the residential school system in the 1900s. In 2015, the first call to action published by the Truth and Reconciliation Commission calls on the government to reduce the number of Indigenous children in child welfare care. One of the calls to action from the 2019 inquiry into missing and murdered Indigenous women and girls calls for full compliance with the 2016 Canadian Human Rights Tribunal ruling. So, what is Canada doing to prevent genocide in regard to the large-scale removal of Indigenous children from their communities and into the welfare system? It has chosen to address this issue through legislation aimed at protecting Indigenous children. In 2019, an act respecting First Nations, Inuit, and Métis children, youth, and families received royal assent and became part of Canada's federal legislation. Within this act, the federal government recognized that the best interests of Indigenous children are advanced when they live with their parents or other members of their family in community. This is so that cultural continuity from one generation to the next can be sustained. The Act also reaffirmed the right of Indigenous peoples to self-governance, including child and family services. However, the effectiveness of this legislative approach as a tool of genocide prevention is undermined by persistent failures in implementation. Stemming from the 2016 Canadian Human Rights Tribunal decision I referenced earlier, the court has issued upwards of 30 subsequent orders to the federal government, many of these for non-compliance with their ruling. The tribunal identified the federal government was failing to adhere to its ruling by adding additional eligibility requirements for care, by failing to stick to timelines previously agreed to, and for dodging accountability. This reveals a critical gap between legislative intent and actual practice. While the Act signals an important shift towards prevention of genocide by prioritizing family unity, cultural preservation, and Indigenous self-determination, the federal government's continued non-compliance with binding tribunal orders suggests that these measures have not been effectively operationalized. Data from the expected census taking place this year in 2026 will reveal whether or not Canada has begun to make fundamental changes to address this issue, depending on if the number of children in child welfare care has increased or decreased since 2021. For now, the risk factors associated with the removal of Indigenous children remains insufficiently addressed, leaving Canada open to risk of being in violation of their obligation to prevent genocide. The United Nations have defined the basic needs of life through the framework of the Sustainable Development Goals. These are 17 goals that were adopted in 2015 that outline the standards of the essential requirements of life that must be met by 2030 for all persons. Most of us understand the basic necessities of life as food, clean drinking water, and shelter. But in the 21st century, basic needs have been extended to healthcare, adequate housing, education, access to information, and financial security and employment. Let's explore 2 of these basic needs: clean drinking water and adequate housing. A 2023 class action lawsuit seeking $5 billion in compensation, launched by St. Teresa Point First Nation and Sandy Lake First Nation, alleged that Canada failed to provide adequate housing on reserve as they were obligated to. The First Nations argued that the inadequate housing conditions on reserve led to overcrowding in homes and forced many to move off reserve to seek safer housing. In December 2025, the Federal Court of Canada delivered their landmark decision in this case, finding that the federal government was indeed responsible for providing access to adequate housing on reserve. Relying on the provisional measures to further prevent genocidal harm of Palestinians in Gaza from the South Africa v. Israel case, at the bare minimum, Canada should be ensuring that Indigenous communities have equitable access to food, essential medicines, clean drinking water, electricity, and heating. Statistics from the federal government have revealed a significant gap between Indigenous peoples' and non-Indigenous peoples' access to clean drinking water. As of recording, of the 41 active long-term drinking water advisories currently in place in the country, 38 are in Indigenous reserves, the longest of which has been in place since February 1995. For Indigenous people living on reserve, their water supply is under federal jurisdiction. This means it is the duty of the federal government to achieve Sustainable Development Goal number 6, the availability and sustainable management of water and sanitation for all. Following the logic of the tribunal in the Akiisu case referenced earlier, inhibiting access to basic needs would not necessarily bring about the immediate destruction of the group. However, it could be interpreted as a violation of the provision in the Genocide Convention against, quote, deliberately inflicting on the group conditions of life calculated to bring about its destruction, unquote. Under the International Covenant of Economic, Social, and Cultural Rights, all persons have the right to safe drinking water and adequate housing conditions. Lack of access to these basic needs make any individual vulnerable, especially Indigenous peoples, who already experience marginalization by the government and settler society. The lack of reliable and sustainable clean drinking water and adequate housing on reserves puts Indigenous peoples in the position of having to choose to stay or move off of reserve. Moving off reserve distances Indigenous peoples from their communities, families, and cultures, impacting cultural continuity from one generation to the next. The federal government has been made aware of these ongoing inequalities through several channels over the years. In fact, the government used to have the Safe Drinking Water for First Nations Act, which became legislation in 2013. This act recognized the obvious importance of access to clean drinking water for Indigenous peoples on reserve, and it committed the government to improving the health of Indigenous peoples, which includes safe drinking water. However, this act was repealed in 2022. After Indigenous peoples shared their concern over its effectivity and risk of undermining Aboriginal and treaty rights. Its repeal was also aligned with the 2021 Agreement in Principle that resolved the class action lawsuit of 2020 related to safe drinking water on reserve. This agreement commits the federal government to $1.5 billion in compensation to individuals deprived of clean drinking water, and $6 billion for supporting reliable on-reserve access to safe drinking water. These commitments, however, have not been legally affirmed by the government. The repeal of the 2013 Safe Drinking Water for First Nations Act in 2021 required new legislation to address this issue, of which consultation with Indigenous peoples was done from 2022 until 2025. However, the prorogation of Parliament in January 2025 halted all progress made on the proposed legislation, and it has not been revisited since. This inaction comes even after the United Nations Special Rapporteur on the Human Rights to Water and Sanitation visited Canada in 2024 and released a statement based on his assessment that urged Canada to prioritize its obligation to provide clean drinking water to communities on reserve. As such, the situation regarding access to safe drinking water is one of continued legislative stagnation that exposes Canada to the risk of failing to meet its obligation to prevent genocide. Regarding adequate housing, Canada did allocate $4.3 billion to address overcrowding, urgent repairs, and the construction of new dwellings on reserve. This budget still falls significantly short of the request by the Assembly of First Nations for $44 billion, as an estimated minimum number of 150,000 new homes need to be built on reserve to address the housing crisis. Since 2022, at least 590 new homes have been built on reserve, and 2,500 homes have been renovated. This does not, however, even pale in comparison to the average 255,000 housing units that have been built in settler communities since 2021. Again, reliance on legislation has proven insufficient. While laws and acts signal recognition, they do not guarantee meaningful outcomes, especially in the case of an actor like Canada, who is slow to cause fundamental changes. Canada had made commitments to ending the clean water crisis on reserves by 2021. However, that deadline has since come and gone, and close to 40 long-term drinking water advisories are still in place on reserve with no federal legislation to legally commit the federal government to ensuring safe drinking water access on reserve. The failure to ensure reliable access to safe drinking water and adequate housing puts Indigenous communities in situations that threaten their health, safety, and overall well-being. Prolonged exposure to unsafe drinking water, overcrowding in homes, and substandard housing conditions increase vulnerability to disease-preventable illness and harm. Though Canada is aware of these risks, the federal government fails to act quickly and decisively to address these issues. As a result, Canada's ongoing inability to remedy these crises leaves it open to the risk of failing its obligation to prevent genocide. In answering the central question this video aims to address, yes, Canada is at risk of violating their obligation to prevent genocide against the Indigenous population. In each of the crises examined, the government had prior knowledge of the risks, including the possibility that its acts or omissions could contribute to the conditions associated with genocide. Although implementation of policy and legislation can be seen as a measure to prevent genocide and the worsening of these crises, they remain insufficient to adequately address and to effectively mitigate the risk of genocide, especially since the government lacks accountability measures for their commitments. The federal government is not lacking awareness, nor is it lacking the evidence of the risk of genocide. What is lacking, however, is the coordinated, Indigenous-led, and sustainable action to prevent genocide. Prevention cannot wait for the perfect conditions or political convenience. Every delay, every jurisdictional dispute, and every unfulfilled promise deepens the harm that Indigenous peoples experience. If Canada is to meet its obligation to prevent genocide, it must act now, and not incrementally, not symbolically, but in ways that create lasting protections for Indigenous peoples. Thank you for watching this video.